6 critical mistakes to avoid when estate planning with your 401k or your IRA. Mistake number 1, inconsistent beneficiary designations. So often what we will see is a decedent has named somebody on their IRA or their 401k as the beneficiary, and then they'll put a different beneficiary on their will. Their will say something like any IRA I have goes to my son or my friend or something like that, and then their IRA actually has their wife as their beneficiary. So that can cause some conflict. Not only does it cause conflict and potentially litigation, but it confuses the heirs and people don't know what to expect. So what happens in that situation? The contract that you have with the financial institution, so your IRA paperwork, your 401k paperwork, the beneficiary designation that you make there is what controls. So even if it has on your will that somebody else is the beneficiary, that's not going to be enforced. Mistake number 2, naming inappropriate beneficiaries. So sometimes we'll see clients who want to name their children as beneficiaries. That sounds reasonable, right? No, it's not. A minor cannot legally inherit funds. So if you do that, somebody is going to have to start guardianship proceedings on behalf of the minor, which is just, you do not want that. It's costly, it's inefficient. So what should you do instead? Name somebody who can be in charge of that minor, or name a trust who can, the trustee for which can distribute funds to your child should they not be 18. Now, once your child reaches the age of 18 or the beneficiary that you want to designate, that's fine. You can name them all day long. Mistake number 3, uninformed spousal designations. So let's say that you're married, you have children, you go through a divorce, you get remarried. You name your new wife or your new husband as your beneficiary for your account. Your kids are then cut out, even though maybe you wanted them to inherit or you wanted them to get some part of your estate. If you redirect the assets to a new spouse, they're going to take, even if your will says something different. So what's the solution for this? Consider putting both your children and your new spouse as your beneficiary, or you can do what I believe is the better solution, and that's to implement a trust that has all of your intentions in one document. Mistake number 4, missing out on tax savings with charitable giving. Charities don't pay income tax on IRA distributions. The problem is that leaving IRAs to individuals creates an income tax burden on those individuals. So if you designate charities as the beneficiaries, you can get a benefit tax-wise for that gift. Mistake number 5, lack of communication with family. This is something that I see all the time. People don't want to talk about their finances with their family, and they don't want to talk about what happens after they die. So they may have everything planned out, but their family is unaware of their accounts, they're unaware of what the decedent wanted, and that can cause problems, that can cause conflict. And not only that, but if you don't communicate with your family where your accounts are held, then they may not even be aware that they exist, and that money may be held up or lost for potentially forever. We don't want that to happen. So keep an updated list of your accounts and communicate with the people that you know are going to be handling your estate after your death. Mistake number 6, neglecting tax withholding on IRA distributions. So the problem we see here is insufficient funds to cover taxes due to non-withholding and penalties for underpayment of estimated taxes. The solution for this is to opt for adequate tax withholding from distributions and to plan for tax liabilities with a financial advisor. So use those professionals, use your attorney, use your financial advisor. They're there for a reason. So in conclusion, these are 6 mistakes that we often see with IRAs, with 401ks. Consult with estate planning professionals to review your accounts and estate strategies.